It seems to me a rather bald-faced and ham-fisted attempt to exert political pressure on a court of law. Tell me why it's not.
Well, I didn't compel those elected officials.
Plaintiffs don't agree with what Sheboygan County adopted, or then how the Planning Commission applied that duly and authorized adopted zoning ordinance amendment. Doesn't change the fact of what the law is.
When the parties alleging this future anticipatory speculative harm have brought nothing to the table for the court to consider than simple generalized allegations that they own property within the county.
The political branches decide policy. Courts of law decide law and legal issues. And we will confine our argument and consideration today to those matters. All right, good morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan, and on our civil division, we are providing public access not only in the courtroom, but also online. So I call the next case of Johnson et al. V. Northern Waters Solar Park and Sheboygan County.
We're in court with homeowners from Sheboygan County challenging a proposed solar project. They're asking the court to step in before construction begins, citing concerns about zoning authority, neighborhood impact, and how the approvals were granted. The town has already taken a position on the project and approved it through its local process. Now the homeowners want the court to intervene anyway. The developers argue the approvals are final and that this challenge comes too late. That's the dispute now before the court.
Good morning, Your Honor. David DeLay appearing on behalf of the plaintiffs.
Morning, Your Honor. Michael Vogt appearing on behalf of defendant Northern Waters Solar LLC.
Catherine Kaufman and Michael Vila hearing on behalf of Sheboygan County.
Okay, good morning. Before we begin the arguments, we've got two matters up. We've got both defendants have filed motions for summary disposition. We also have the plaintiff's motion to compel discovery. We'll take the motions for summary disposition first. But before I invite argument on that, I want to make a disclosure then that within the last week or so, my office received correspondence from a member of Congress and a member of the state House of Representatives, my staff, about their views about this case, as is standard practice, although I'm not suggesting it was improper for the sending of those letters. Sometimes in criminal cases, I get letters of support for defendants. Legally, that's an entirely different matter. So I'm not suggesting there was anything improper in the sending of them, but it'd be improper for me to receive or review them. So my staff returned them unread with information to that regard. And then to my surprise, as I was reviewing the pleadings in this matter, which were quite extensive, I see attached to the plaintiff's response what the plaintiff's counsel says are amicus briefs to see the letter from a member of Congress. And I confirmed with my court administrator that that was the letter she had received and returned without my review. So obviously, because it's attached to the motion and the information was given to both sides, I saw it. Mr. Delaney, I would like you to explain to me why you believe that is an amicus brief and what legal claim it pertains to, since the letter only seems to complain about Chinese interests in the company involved.
The premise of my response does not involve those letters. I did include them. They're constituents of my clients. My clients met with both of these offices in this case. Let me start with the more recent letter. I wasn't aware that was coming to the court, and as soon as I found out, I let the counsel know for the defendants in this case. They aren't amicus briefs. My clients had spoken to those offices and asked if they would file amicus briefs in this case, and they did not. They chose to send letters. So I didn't engineer those letters to the court. And so
you called it an amicus brief.
Correct.
And you admit to me it's not.
Well, what happened was I met with my clients on Friday, the day after New Year's, to provide these documents. When he arrived, he thought it was an amicus brief. He doesn't know what an amicus brief is.
But you do.
Right, correct.
This is the materials you submitted.
That's correct.
I want to know how you think that satisfies your duty of candor to this tribunal.
Well, it did. I thought that I provided that to the both attorneys in this case in advance. Now, it may be a mislabeling. I understand that.
Well, beyond that, by your acknowledgement here today, it has no bearing on the legal claims, correct?
That's correct. But I don't it's not impermissible to provide that to the court.
It seems to me a rather bald-faced and ham-fisted attempt to exert political pressure on a court of law. Tell me why it's not.
Well, I didn't compel those elected officials to draft those.
You
letters of
attached
support.
it.
That's correct. The first one
They
I
can
did.
send what they want and
Correct.
we send it back. When
Yes.
you attach it,
Correct.
you're saying you want me to read this.
That's correct.
Explain to me why.
I don't see why it's improper to do that, Judge.
Well, it
If
completely
they want
is.
to weigh in, now I provided the court with hundreds of pages of other documents that are going to be the substance of this case.
Right.
But those provided to the other, the court can simply read it and not give it any weight at all.
I have not.
But right, and I'm not saying, I don't see why it's improper to provide that to the court.
It surely is.
Okay.
I'm not going to take any further action about that other than to disregard its contents and have chastised you publicly about it. I'm not going to take any further action on it.
All right, thank you.
Anything to be said to that, Mr. Vogt?
No, Your Honor, I think you covered it. Thank you.
Ms. Kaufman?
No, Your Honor.
All right. Many of the arguments presented by the plaintiffs, consistent with that letter, are political and policy oriented. That's for the political branches to decide, not the courts. You know, courts aren't blind and deaf and dumb, and I know that this is a matter of public import. But the political branches decide policy. Courts of law decide law and legal issues. And we will confine our argument and consideration today to those matters. Mr. Delaney, go ahead with your arguments. Or I'm sorry, you're the respondent. Mr. Vogt, go ahead with your argument in support of your motion for summary disposition.
Thank you, Judge. Good morning, Your Honor. Michael Vogt again on behalf of Northern Water Solar LLC. I know the court has had an opportunity to review the pleadings and extensive briefing in this case, so I won't belabor all of the arguments that we made in those documents. But a few points I think are worth emphasizing before the court rules or takes this matter under advisement. The first point being that this case, Your Honor, is truly a simple zoning case. While there are many pages spent in the complaint and responsive briefing, discussing and criticizing and frankly mischaracterizing Public Act 233, the fact of the matter here is that that statute has zero relevance to this proceeding and it has zero relevance to the underlying zoning decision.
Well, I mean, that was, can I ask you a little bit about that? That was one of the themes of your motion, that this was just an approval of a special use permit under a zoning ordinance, so that Public Act 233 is wholly irrelevant. But it wasn't just the existing zoning ordinance before Public Act 233, right? It was under the amended ordinance, which was a, what do they call it? A compatible renewable energy ordinance, is CREO, how that's pronounced, CREO, that it was a CREO. And by the terms of the written amendment, it was intended to be a CREO to comply with Public Act 233, right?
That's fair. I can address that, Your Honor.
Sure. So why isn't, so that as I understand the plaintiff's arguments about that, it's that Public Act 233, if it impermissibly required local units of government to adopt such an ordinance, would be relevant to any applications that were approved under that CREO.
I understand that, but it's kind of based on a couple of premises that aren't exactly accurate. And that is, for one, there's nothing in Public Act 233 that requires a municipality to adopt what is known as colloquially as a CREO, compatible renewable energy ordinance.
Right, I agree. I've read the statute.
So,
there's nothing in there that would do that.
And so the step back to make what's clear is that a CREO is by definition just a zoning ordinance. It's a zoning ordinance that has certain standards and requirements that allow it to fall within this category of zoning ordinances that PA 233 addresses. And so while PA 233 may have been, let's say, the legislative inspiration for this zoning ordinance. This zoning ordinance is adopted purely in accord with the Zoning Enabling Act, under the procedures of that act and the Planning Act. There is no process or procedure under PA 233 whereby any ordinance can be adopted, zoning or otherwise. So the reality here is that while we are operating in the world where PA 233 exists in that universe, and where ordinance and municipalities are free to adopt a zoning ordinance that falls into the category of a CREO, as the court has acknowledged, they're not required to. In this case, the zoning ordinance that was adopted by the Sheboygan County Planning Commission was intended to be a CREO on its face. That's what the text of it says. But whether it says this is intended to be a CREO, this is intended not to be a CREO, or it was completely silent as to the intent of whether it be a CREO or not, would have no bearing on the outcome of this case or on that zoning decision. It was a properly noticed and duly held public hearing for a land use permit. The fact that that ordinance qualifies as a CREO, at least under the opinion of the county, that's great, but it has no bearing here.
Because your client, as I understand your position, if your client doesn't think it can meet the requirements of a local zoning ordinance under Public Act 233, can petition for some site certification approval through the Michigan Public Service Commission. Is that right?
That's correct.
And then there's public hearings in the areas where the project would be. And if those units of government tell you, well, we have a CREO, then you have to go to them first.
That's correct. So this is why Public Act 233, while it exists and it's referenced somewhere in the zoning ordinance, why it has no applicability here. As the court just acknowledged, a developer has options when it goes to get its land use and siting approvals with now that PA 233 has been enacted.
So if your client looks at at a potential project and sees a local ordinance that is not a CREO, but they think, we think we can hit these marks. They can, but aren't required to. They can just petition under that ordinance without going to the MPSC. Is that right?
That's correct. As the court noted, the MPSC process is a full administrative proceeding, contested case. And so developers have and really are incentivized, frankly, to find ordinances where they can meet all the local regulations. This ordinance, whether you call it a CREO or not, was such an ordinance, and that the developer said, forget the state process. Let's work with the local community here. Let's permit this thing locally. We can meet it. And I can tell you, I've taken several projects to the MPSC, but most of my projects are locally zoned. And when you go to the MPSC, there's a procedural process and steps that have to be taken, none of which were taken here by this developer. They simply submitted a local zoning application and followed the MZEA process for land use approval.
Okay. Now I'm maybe more interested then in your arguments about standing and whether the plaintiffs have suffered any injury from the alleged constitutional violations.
Very good, Your Honor. Happy to address those issues. Starting at the end of the sentence, the constitutional issues, my client being a private actor and not a government entity or representative of the government, we would ask that those be dismissed out of hand as they apply to us. We also address the merits of those claims in the brief, in that they have not come close to touching the very high burden of establishing a due process or equal protection claim. And I won't belabor those because they pertain more to the county.
That's true. That's a good, your client didn't violate anybody's constitutional rights. Your client applied for special use permit. Okay.
Yes, that's correct. So withstanding to the court's inquiry, which was the second point I wanted to make here, is that not one of the 19 plaintiffs in this case can satisfy the requisite standing for a single one of the 10 claims that have been brought in the complaint. And that includes the claim of appeal. To the nuisance claims, Your Honor, the easiest and most obvious reason these should be dismissed out of hand is ripeness. These issues are not ripe for any sort of adjudication in that the project does not yet exist and ground has not been broken. The rare and extreme circumstances where courts have found that some sort of anticipated harm simply are not present here.
Well, why not? The alleged anticipated harms would be fairly significant and allegedly permanent So why must plaintiffs wait until the project is constructed, thereby causing possibly permanent harms before they sue about them?
To answer that question best, Your Honor, it's that, well, allegations have been thrown against a wall. Those allegations at this point of the case need to be tested to some degree to have some level of evidentiary support,
That's
something
true.
to stand upon.
That's true. That's
And
true.
these allegations that have been made do not have that. And I'm prepared to address why they have been addressed by wholly inadequate or incompetent and certainly inadmissible evidence in the form of affidavits jammed with legal conclusions that are copy and pasted from one plaintiff to another. Not a single plaintiff has identified the actual address. When you look at the complaint, all the affidavits in the briefing, we don't know one address of one property owner. So how could we possibly have gotten to this level of specificity necessary to establish future harm when we don't know where a single property owner's residence or property actually sits? All they've alleged is that they are either adjacent to or negatively affected by the project.
Right. There needs to be something more fleshed out about that. I agree. Let me just tell you frankly, if we were here at the end of discovery, I'd 100% grant your motion in that count. But why should I not allow these plaintiffs to go forward with litigation and discovery? Have they not come forward with enough information at this early stage to allow that claim to survive?
Michigan law, Your Honor, does not recognize these claims under these circumstances. It does not recognize private nuisance. It does not recognize public nuisance, and it certainly does not recognize nuisance per se under these circumstances of a duly approved zoning project, which passed muster of all special land use standards and was fully supported by competent evidence. When the parties alleging this future anticipatory speculative harm have brought nothing to the table for the court to consider than simple generalized allegations that they own property within the county and that they may be negatively affected at some point in the future. This would not establish any level of standing as to the harm that's different from others in the community under Saugatuck for their claim of appeal. It does not establish the requisite standing for either nuisance claims, public or private. And with respect to the PA 233 claims, those should be, there's no case or controversy, frankly, because the statute's simply not implicated here. The court, Your Honor, they're entitled, these plaintiffs are entitled to their policy opinions, their political opinions. They're entitled to be opposed to this project. I respect that opinion and their right to have it. They're entitled to be opposed to all of solar projects in the entire universe. But all of their personal opinions, while they're entitled to have them, they do not give them standing in this court, and they do not change the plain, simple zoning record of the approval underlying this matter.
Yeah, and I think I made it plain in living color that I wholly agree with that statement. But then in some of the attachments, now granted, I'll grant you that I'd like to see more specificity maybe about which plaintiff's property, if any, this is. Some of these attachments depict, an area, presumably one of the plaintiff's parcels before solar, and then with the benefit of some kind of AI or image manipulation, how it would appear once the solar project is completed, and they're like completely surrounded by this. If that's one of the plaintiffs, isn't that enough for them to at least litigate these questions?
No, because the key word you use there, Your Honor,
is if.
If and presumably. Presumably one of the plaintiff's properties, yeah, I guess that'd be a presumption you could make. But what you're looking at there is so far from a piece of admissible evidence that I don't even know where it would fit into the judicial proceeding. What you're looking at is land of someone somewhere with no description, with an AI generated overlay of solar panels. I did take a look at that in the time I had since the response brief was filed. The solar panels have little to no relation to the actual site plan in this project, and where they've been approved. They don't reflect any of the setbacks or any of the conditions that were put on the project. There's no authentication. For all we know, that image was put into an AI generator, said create solar panels over the top, and then submitted to the court. What that presents evidence of to any relevant issue of fact here, I don't know.
Okay. And then what about the the allegations that the plaintiffs have made pertaining to health hazards attached with this opinion from a public health physician in St. Clair County. That's not enough for them to at least litigate these claims and go through the discovery process?
The answer, Your Honor, respectfully is no. And the answer is no here in Sheboygan County for the same reason it was no in Otsego County when that same opinion, that same medical memo was submitted in support of the plaintiffs there with the copy and pasted, for the most part, claims that are again reiterated in this case. The court there, I would suggest, as the court here should find, held that, well, that doctor's entitled to his opinions. It was related to a specific project in a specific county, neither of which were implicated there, neither of which were implicated here. Well, and as noted by the judge, there is totally unsupported memorandum from a doctor that has no involvement in this case and has not submitted anything to this case, to my knowledge.
Sure. I mean, I'd agree if we were, again, at the end of discovery, but here where discovery is only just started, the plaintiffs just have to show that they are going to be able to present some evidence about this, right? For you to win at this stage on that count, you'd have to prove that there's no reasonable basis that the plaintiffs could be expected to produce any evidence on that count.
Under C10, I agree with you. It's also the alternative C8 motion that their claim, even taking it at its face, does not support a claim that could be awarded relief or that could even be sustained.
Why not? I mean, even if something is approved by zoning, my neighbor could be doing something that's approved by zoning, but it interferes with the reasonable use and enjoyment of my property, and I have a private nuisance claim. Why would they be out on C8?
Because I would say, because Michigan law doesn't recognize this hypothetical perspective, a private nuisance claim for a project that doesn't exist yet and might exist in the future. Under the case they cited, Pigeon, actually Ashkay versus Pigeon, actually cut, and that's a case I'm involved in with my partner, Dan Quick. It actually cuts completely the other way. The reason that the Court of Appeals there found that there was enough of an allegation of harm here with some evidence to back it up, because the nuisance had already been created. The decision from that municipality allowed the construction on an island of a residence. The residence was constructed. It was already operating as a short-term rental. The issues that the plaintiffs complained of in that case were real. They existed, and there was real dangers presented. Here, as a matter of a C8, Michigan law does not even recognize this claim of a future nuisance of a project that hasn't been built yet.
So your client's position would be that the project would have to be built, and then if it in fact interfered with the use and enjoyment of anybody's property rights, then they'd have to sue at that point.
Or if there was, or I guess Michigan law would recognize if it was imminent. Of course, they could come ask Your Honor for injunctive relief. They wouldn't have to wait for something to happen necessarily. But the fact is, the reality here is that the short answer to the question is yes. You don't have nuisance claims for what something might happen in the future, what someone might do in the future. Nuisance claims involves an invasion, non-trespassory invasion from one property to another. Nothing has been alleged to have invaded from anyone's property onto any of the property owners' land here, land again, which we don't even know where it is located.
But it's not entirely hypothetical when there's a site plan, like if I can't sue my neighbor for because they're having a party next weekend and I think it's going to be too loud.
Yeah.
That's entirely hypothetical, and I'd have no way of proving
And
that.
the appropriate,
But here there's a site plan, and there's plans that this is going to be actually constructed, and here's the manner in which it's going to be actually constructed. So it's not hypothetical what's going to be there. So it seems to me the plaintiffs ought to be allowed to litigate the question about whether that's going to interfere with their property rights.
And to a certain extent, the court is correct. That forum, that mechanism, is not a nuisance claim for a potential future harm. It's an appeal of a zoning decision where they look at the special land use standards, which what do they normally look at more than anything? How will it impact surrounding areas? How will it impact any negative, have any negative impact on the community? That, in this case, that was done. And the recourse for these plaintiffs, if they were to have done it correctly and established standing, would be to file a claim of appeal saying the special land use standards, the zoning ordinance has been misapplied. I will be harmed by this project. Circuit Court Judge, please review this under the standards of the court rule here. And they have tried to do that here for the reasons we pointed out in our brief. I believe they failed to establish the bar under Saugatuck Dunes for aggrieved party standing.
Okay, and it's very unusual that then they would have tacked on the claim of appeal to this action. I mean, when I've seen that happen in other cases, there's a civil action and an appeal separately filed. I haven't yet seen one where they're combined, but count 10 is a claim of appeal. Generally, summary disposition is not available in an appeal, right?
You're absolutely correct. If we were arguing about the merits of what they wanted to brief and what they wanted to argue on appeal, the dismissal here is appropriate because of the threshold question of aggrieved party standing. And the Saugatuck Dunes case, I won't go belabor it, lays out the three-pronged test. Here, only 5 of the 19 plaintiffs even satisfy the first prong, which is that they showed up at the public hearing or submitted a statement in writing. So out of hand, 14 out of 19 appeals should be dismissed because they did not satisfy the first prong. The remaining 5 that did appear and make comment, none of them can satisfy the second and third prong of the Saugatuck Dunes test for the.
Wouldn't that, or let's say that the civil action weren't filed, but this was just a claim of appeal that had been filed. We haven't even gotten the appellant's brief. Normally we get the appellant's brief, then you'd file a brief, and one of the arguments in your brief would be that they don't have standing, and then we decide it that way.
That's one certainly absolutely a valid way the procedure could have gone here. But due to the fact that there were these 9 other claims that were bootstrapped to the claim of appeal, obviously our initial response was a full motion for summary,
Yes, okay.
and they had the opportunity to then establish their standing and say, here's when we participated, here's the specialized harm, here's the damages. That did not happen.
Okay. All right, thank you. Anything else I need to know to understand your position?
No, I don't think so, Judge. Appreciate the time.
Thank you. All right, Ms. Kaufman, Sheboygan County.
Good morning, Your Honor. Again, as Attorney Vogt said, our briefing contains our responses and our arguments for motion for summary. We again want to focus on, and I will not belabor it at this moment, you've just heard it. The zoning ordinance amendment, ordinance 186, was adopted a year ago, was properly adopted. Public hearings, the County Board of Commissioners adopted it. Nobody filed a notice of intent to file a petition to challenge that ordinance. So it became effective on February 12th of last year. The applicant thereafter applied for approval of a project. The Planning Commission went through the requisite requirements. Noticing was held, public hearings were held. Everybody was actually given more notice than required because it was noticed as a special use approval. All that was done. The decision was made by the Planning Commission and it was appropriate. They found it to be appropriate to grant the approval. The aggrieved party status is to us very appropriate to bring this motion at this time, as discussed by Northern Waters Attorney Saugatuck Dunes Coastal Alliance case from 2022. Michigan Supreme Court governs who are aggrieved parties. And again, your point about the appeal is absolutely right. The court rule 7.122 requires that you be an aggrieved party, even bring the appeal. We contend that these people, 19 plaintiffs, are not aggrieved. And additionally, if in fact you were determined some or all of them are aggrieved parties, then the court is looking at this appeal under MCR 7.122, which was the decision authorized by law and was it supported by competent material, substantial evidence on the record, which was quite an extensive record that our firm filed. So we believe that at this point in time, it is appropriate for the motion for summary for all the counts, including the appeal, because of the aggrieved party standing question.
All right, can you address, well, I mean, as to that question, would you agree that, I mean, summary disposition is generally not an available procedure in an appeal to the circuit court?
Except for standing, aggrieved party status, the Saugatuck Dunes
Even with
Coastal.
that, like, okay, let's say that I make a decision that you don't like and somebody goes up to the Court of Appeals. Nobody files in the Court of Appeals a motion for summary disposition, and it gets dismissed as improper if they do. And the rules governing the appeal are in chapter 7.100 of the court rules. There's no summary disposition in that chapter.
However, standing can be brought at any point in time, and this is an aggrieved party. You have to be an aggrieved party under 7.103 to even bring the appeal. We contend they are not aggrieved parties.
Okay. Can you address for me all of the plaintiffs, I guess, constitutional claims? You don't have to address them each seriatim or in detail, but just in a nutshell, why your client believes that plaintiffs have not established that they have been injured, even if there was any constitutional violation.
All right, so in terms of the constitutional claims, first of all, again, having difficulty determining what some of the counts we're asking for. Count 4 is apparently an equal protection claim that the county somehow, in choosing some zoning districts to have level 3 solar projects, special uses, and some to allow it as permitted by right. First of all, again, I'll start with the overlying premise that zoning ordinances are presumption of reasonableness. They're presumably valid, okay? We have the whole analysis of Grayburn versus Bloomfield Hills, the court should not sit as a super zoning commission, et cetera.
Sure, it seems to me that the very essence of zoning is to determine in which districts to allow certain uses and in which districts not to allow certain uses, right?
That's correct, and that decision is made by the legislative body, which in this case is the County Board of Commissioners upon a recommendation of the Planning
All right, so
Commission.
I don't get to rewrite a zoning ordinance and say this use ought to be allowed in every district.
No, we contend that's correct. And additionally, the equal protection count is somehow plaintiffs saying they would have been harmed by certain districts allowing solar energy projects, large renewable energy projects, certain not. Plaintiffs have no harm. They weren't asking for approval of a solar energy project. Northern Waters was, but not harmed. They were not treated dissimilarly, anything like that. The next count, 5, was it the plaintiffs believe it's constitutionally unreasonable for solar farms to be allowed in some districts and not others. We've kind of talked about that. So we had an equal protection count. We had this other count about who gets to decide where certain uses are allowed. That's correct. We just discussed that. That is not for the court to decide. That's a legislative decision. Then we go to the nuisance claims. As already discussed, we would agree that they are not ripe. They are not ripe for adjudication at this point in time. Count 8, that was count 6 and 7, private and public nuisance. Count 8 talks about the dark sky friendly lighting component. That's in Public Act 233, which is also in the county zoning ordinance. We do not feel it's void for vagueness. There is a definition of dark sky friendly lighting is cited in our brief right out of the Public Act, and it's also
Light fixture designed to minimize the amount of light that escapes upward in the sky.
right. So when the
If that's vague, if that's unconstitutionally vague, our Michigan compiled laws are going to be down to about 1 volume.
Agree. And I also believe that it's the applicant's duty to figure out how to comply with zoning ordinance requirements.
That's right.
That was count 8. Count 9
Preemption.
was where they asked you to find that the voluntary standards are lawful. I'll just make a very brief statement. Northern Waters attorney discussed what a CREO is, discussed what a workable ordinance is. The only thing that matters in this particular matter is the county adopted a CREO. The county's CREO has the 5 standards that match the state law, but then they also had voluntary standards. Voluntary means voluntary. It means I don't have to do it if I don't want to. All right.
Because as I understand it, looking at the record here, then that they're faced with sort of a choice once Public Act 233 is in place. Do we want to have a seat at the table and be part of the conversation or not? And so if they want to be in conversation with the proposed developers, they have to have this CREO, and then they can talk to them about being good neighbors or whatever.
So that's exactly right. The only way under Public Act 233 to require a developer to come through your
Is they have a
municipality
CREO.
is to have a CREO. And the
Because otherwise,
CREO,
if you try to regulate it beyond that, then they're just going to skip you and go to the state.
that's right. That could
Do I
be their,
understand that
that could be their
framework?
business decision, correct. And in this particular case, the CREO ordinance said, hey, if you want to do more, we tear it, correct? So in terms of count 9, we don't believe that the inclusion of voluntary standards in any way violates this being a CREO, and it is a CREO. And then in terms of the appeal, we already discussed why we feel it's appropriate at this point in time for summary disposition. And even if the court was to find aggrieved party standing, we do believe that under 7.122, the county has provided an extensive record that the decision made was authorized by law and based on competent material, substantial evidence in the record. The minutes are there, et cetera. So under C8, which goes solely on the pleadings, we believe that motion for summary disposition is appropriate in this case.
All right, thank you. Mr. Delaney, your response to those arguments?
Thank you, Your Honor. If you had the choice of adopting an ordinance that has 5 requirements to protect your citizens or 50, why would you pick the 5? And that's one of the.
Well, I don't know, but I'm not a member of the Board of Commissioners. There could be all sorts of reasons why somebody would do that.
But it violates equal protection because you're not providing protection to your citizens only for one type of developer. We already have pending in this court, Sheboygan County versus the Hope case. And in that case, the county sued my client because he did not comply with the ordinance. And the court was well within its province. I wasn't involved then, and I don't actually disagree with the court, to have reversed the planning commission's finding in that case because he did not comply with the ordinance. Specifically, the road, the dust, the noise, and the neighbors and things like that. If Hope had a CREO, you couldn't have done that because you'd have been limited to the 5 requirements. So solar developers are being singled out in Sheboygan County and throughout the state of Michigan. They only have 5 requirements, and they're barely requirements, fencing and heights and sound and things like that.
How's that violate your client's rights to the equal protection laws?
Well, I'll show you. This is a site plan, and the court does have the AI added solar panels. But this is the site plan for EDP in this case. And we're not requiring or requesting the court have to go through all the filings in this case, but most of the plaintiffs in this case live near this site. This particular area, this red box, this is their site plan by EDP, is Johnson. That's the gentleman seated at the table here. He's going to be surrounded by solar panels in this case. When he acquired his property, he had the full protection of the Sheboygan County zoning ordinance. 50 requirements, lakes and streams and wildlife, effect on neighbors. So I think he felt protected here. Well, Sheboygan County changed that in January 2025, and they stripped him of his protections. He has none now. All the requirements, the 5 of them, are on the developer. Just have a fence, don't be too noisy, make sure there's certain height. I disagree with the court about the friendly lighting solution. I think that's a pretty poor definition in my estimation. And there's setbacks. If you look at the Sheboygan County zoning ordinance, for example, substantial negative impact is one that hooks many of my clients, but they can't apply that here. So Mr. Johnson now has the right to challenge this ordinance because he has 0 protection in this case. And I can say this. Once
I
this
think
is built,
how are you not turning equal protection on its head? You're arguing that because government is not regulating property enough, that violates somebody's equal protection rights. An equal protection claim would work like this. You go to the county commission and you want to do something on property you own. And the county says no. And then you say, well, wait a minute, the restrictions they're putting on me are violating my equal protection of law, constitutional guarantee, because they're not saying no to other similarly situated people. I just am failing to grasp how your client's right to the equal protection laws have been violated by some government action beyond just your general claim that they think this zoning ordinance is not restrictive enough. I've never heard of such an argument.
well, ordinarily, it's the developer coming in saying, I want to use my property like other people use their property, but you're restricting me in this case.
Right.
And I say PA 233 turned the whole zoning designation upside down. And they selected solar. Only solar gets those special treatments in this case. And so the neighbors and the residents of Sheboygan County are out on protection. They have no protection from solar in this case.
There are some communities in the state of Michigan that are unzoned, is that right?
There may be some, yes. I've heard. I've never been to one. Okay, but that's their choice.
I mean, nobody has a legally cognizable or enforceable right to live in a zoned community, do they?
That's correct.
Okay, then that kills your equal protection claim right there.
We don't have an unzoned community. We have a zoned community. Look what happened in Otsego County and what's happening in St. Clair County. Now, the Otsego case is mine. And in that case, they disregarded the PA 233 Creo. They just kept their own ordinance. And because of that, Judge Hunter said, you have all the protections that you've always asked for in this case. They remain in place. So I don't think these municipalities believe they can keep their own ordinance. Like the old phrase, if you like your doctor, you can keep your doctor. I don't think they're being told that. You have to have a Creo in this case. And if they don't have a Creo, does that give the developer the right to go to Lansing to the Michigan Public Service Commission? I don't think that's clear in PA 233. In fact, the section cited by Otsego County and probably St. Clair County is that if the MPSC has not issued a certificate, the local zone ordinance remains in full force and effect.
All right, but how are those not just policy arguments that you know, Gaylord or St. Clair or some other county could say, you know what, we're gonna fight this. We're gonna have a zoning ordinance that still has some teeth, by golly. But Sheboygan County didn't do that. They adopt a Creo for whatever reasons. I mean, this court really can't get into the heads of the county commissioners. Maybe they like solar. I have no idea. What, you know, I'm presuming that they adopted the Creo because they felt like, as I alluded to, they want to have a seat at the table to talk to these developers.
Well, I disagree with that because if you don't have a Creo, then your ordinance remains in full force and effect because the MPSC has not issued a certificate, which they have not. So what gives them the right to go to Lansing? We haven't litigated that. This statute is gonna see quite a bit of appellate activity in this case. And could the developer in Otsego County gone to the MPSC? They say they could have, but
So
they didn't.
your argument seems to be, well, Sheboygan County caved to the state and shouldn't have. Well, my question to you in a court of law is, so what legally?
Because my clients have no protection. The Sheboygan versus Hope case, it's been 3 years. He still doesn't have a permit. So let's say that the court's docket changed dramatically and you had nothing but zoning cases. I'd be pleased to do that. When these zoning cases come in, Hope and other ones, you're going to go through the Sheboygan County zoning ordinance, all those requirements, and determine whether or not it was a valid permit, except when solar walks through the door. They had a special pass. In fact, they're a use by right. Another equal protection violation, which is different than your standard, I agree. That's a drive-through permit. Just walk down to the zoning office, meet the 5 requirements, and you get your permit.
Sure, but they didn't do that here. They applied for a special use permit.
Well, you could call it that. I mean, they went to the planning commission really didn't have jurisdiction because it's a use by right. They protest that, but they're incorrect. It's in the ordinance. It's a use by right. I don't know why they went to the planning commission. I think it was for a public display. But the planning commission really had no authority to issue a special use permit. It's not a special use permit.
Maybe you want to take some time explaining to me why your count 6 private nuisance should survive at this early stage of litigation.
And that's because you look at the Moncrief case, and Moncrief talked about that. And the other case that also talked about anticipated harm in this case, the Pigeon case. Both of those cases indicate that anticipated harm is sufficient to allow the case to go forward. Now that may change once discovery is done and the court finds that there's no basis here, but I think it's related to the equal protection arguments. The Johnsons and other plaintiffs in this case are not going to have any protection from this solar project. They have no place to go because the zoning ordinance offers 0 protection. It did, but they changed that. Now, if it was changed across the board, that'd be fine. But only one business and entity in Sheboygan County has the 5-part test, and that's them. So they're related. The nuisance claim is related to the equal protection claim in this case. They have simply no protection in this case. In the voluntary regulations, Judge, I've never heard of that. No one has voluntary regulations. I appear in front of zoning boards all the time. They never ask me what I'd like to require in my ordinance. I tell my clients it's a bit like this, like go to the beach and the sign says no guns, no dogs, no swearing, no alcohol. And then it says these regulations are voluntary. Who's gonna follow them? What's the point of a voluntary regulation in this case? I wish Mr. Hope had voluntary regulations, because if he did, when the court reversed his case, which was for good cause, what about the road? They didn't address that. What about the neighbors? What about the dust in this case? Mr. Hope would have said, those are voluntary, Judge. And he would skate on by in this case. This is what I'm going to be asking the court to do at the end of this case. Void that CREA and then reinstate the old ordinance and change the districts. The
How
districts.
do I have the jurisdiction to do that just because you think that was a bad political judgment? What is legally wrong with that CREA?
I don't attribute politics to this case at all. The developers
Wow,
routinely
Mr.
say
Delaney,
that
you're
I don't
really-
like solar, and these are grounded constitutional arguments on these districts. Only 5 of them allow them. For example, the conservation district in Sheboygan County, no solar is required, is allowed. Why? The Lake and Stream Protection District can have solar, but the conservation district can't in this case. And the list goes on and on. The north end of one of the lakes here in the White, Burt Lake, no zoning at all. They're exempt from that. Even the marijuana district, Judge, they don't have to have solar projects in this case. The residential districts don't have to have it. How can Sheboygan County adopt an ordinance in good faith? That's arbitrary and capricious. That's my position on that. Indian River, top of the V, rural character. The Natural Resource Protection District, the Resource Conservation District, the residential development, the Lake and Stream Protection, that is the 50 megawatt level 3. But the Lake and Stream Protection District here, look at the districts that it's allowed in, industrial and farming. How could you put those two together? Speaking to the county in this case, it's completely arbitrary. It looks to me like they picked those districts because that's where the developer had his leases, and that's where the utility lines run along the lake. When we ask these questions, I know it's not the time for the motion to compel of the county, and they defied us. If they don't have anything to hide, if these are as clear as the court is suggesting, then answer the questions. Tell me why these districts are laid out the way they are. Tell them why it's a use by right, why it's a voluntary regulation, and why solar gets 5, but the rest of us get 50.
Anything else I need to know?
No, any other questions from the court?
Yeah, well, yeah, about the appeal, the claim of appeal counts. You haven't yet filed your claim, your brief on appeal. It looks like that would have been due by my calculation, last Thursday, January 8th. Are you filing the brief on appeal?
Well, I wanted to find out what's going to happen to these motions for summary, but I would point out.
How are your clients aggrieved parties under the zoning standing rules?
Well, under the rules in Saugatuck, I believe most of them appeared and protested the zoning. If the court finds that not all of them did, then the court can address just the appeal. Because remember, Saugatuck wasn't a separate filing. In my recollection, Saugatuck was original action of the circuit court on the nuisance claims, and then the appeal. It was put into one appeal, which is the reason I did it that way. I really don't want to have 2 cases pending at the same time, and you might have consolidated them. But I think discovery will yield that, and I probably need to tighten the hatches on the affidavits on where they live and if they protested and things like that. But I know some of them did. So,
But
the court,
even by you putting it in the civil action, the rules of appellate procedure would still govern that count.
that's correct.
Okay.
And we were timely. And since I wanted to be 21 days across the board, even in my original, even though I wasn't required to, and I think they're interrelated. And if you look at the Administrative Procedure Act, which is incorporated into the 700 rules, you can appeal constitutional issues in an appeal. Ordinarily, as you did in the Hope case, you looked at the record, you didn't see anything about the road, you sent it back. But Hope could have raised constitutional issues in that appeal. He didn't have any, but these people do.
Okay, anything else I need to know? I'm sure.
No, thank you.
Thank you, Mr. Flynn. Any rebuttal argument, Mr. Hurd?
If I could be very brief. Thank you, Judge. Well, I think what I took away and what is most maybe glaring from oral argument presented by plaintiff's counsel and in the briefing is there's a flat out disingenuous undertone to the claims that have been brought to this court. To stand here today after making nothing but policy and political arguments, to the extent it sounds like a stump speech that would have been made after a referendum on these ordinances, which never occurred, by the way, is disingenuous. Everything that has been argued is a second guessing of the wisdom of either the county commission or the county planning commission adopting Public Act 233. To stand here and say that there is no political incentive or motivation behind the case, I think is it's obvious, and that's not true here. To briefly address the final two things. One, with respect to the appellate standing, it is appropriate and proper to bring a summary motion on a claim of appeal if it is a jurisdictional issue. The jurisdictional issue here is the aggrieved party status, and it's also the following of MCR 7.122 when you lodge that claim of appeal. It requires concise statements that outline the basis for the appeal. All we have here is one conclusory paragraph saying that it failed to follow the Constitution or be submitted by evidence. They did not, supply any detailed, concise statements. The other prongs of the aggrieved party standard, I won't belabor again, under Saugatuck Dunes, simply have not been satisfied. And turning lastly to the nuisance, again, Your Honor, the case law submitted, I won't go through and cite everything, but it stands for a couple of very simple propositions. And that nuisance claims cannot be based on speculation and conjecture. They cannot be based on, quote, unfounded fear about dangers in the vicinity of the property, end quote. And if a court was to entertain some sort of injunctive relief for a future nuisance, the case law is very clear that those situations require a practical certainty that the nuisance is about to exist. The only certainty here, based on the land use approval we have, is that the project can be built. To operate under the assumption that the simple construction of the project equates to a nuisance, there's no evidence of that. And frankly, all of the evidence would be to the contrary based on the land use approval that went through the Planning Commission. So we cannot operate under the assumption that, well, they've established that there's going to be a solar field, so then they're going to have a nuisance in the future. No, they've established there's going to be a solar field in the future and nothing more. If and when the day comes when something invades upon their property that amounts to a nuisance under Michigan law, they will have their day in court before Your Honor. That's all I have.
Okay, thank you, sir. Ms. Coffin?
Briefly, Your Honor. Again, the court cannot sit as a super zoning commission, and simply because plaintiffs don't agree with what Sheboygan County adopted or then how the Planning Commission applied that duly and authorized adopted zoning ordinance amendment doesn't change the fact of what the law is. Secondly, this is not just for solar energy projects. Wind energy projects and battery energy storage projects are also all regulated under Ordinance 186. So large-scale renewable projects, wind, battery, and storage of certain threshold megawatt sizes are regulated under this ordinance. Thirdly, simply because plaintiff's attorney hasn't heard of something in a zoning ordinance doesn't mean it's illegal, doesn't mean it's arbitrary capricious, doesn't mean it's unlawful. All right? Fourthly, if we really want to bring up the Hope case, we can bring up the Hope case.
Yeah, it's really not fair.
All right. Thank you, Your Honor. Appreciate that.
All right, well, both defendants have filed motions for summary disposition of all of plaintiff's 10 claims under Michigan Code Rules 2.116C8 for failing to state a valid claim on which relief can be granted, and under C10 where there's no genuine issue of material fact and that the defendants are entitled to judgment as a matter of law. Many of the plaintiff's arguments are policy oriented, which, as I indicated at the outset, is for the political branches to decide, not the courts. Whether a large-scale solar project is good for Sheboygan County is simply not a question for me. It's not a justiciable question. Whether this particular solar project is good for Sheboygan County, or whether the fact that a shareholder interest is held by a Chinese company, it is not within the jurisdiction of this court. I am not a legislator. I do not sit on the Board of Commissioners. I do not sit on the Planning Commission. So whether I would have voted for PA 233, the Sheboygan Creo, or the special use permit, or whether I think that they are imprudent is entirely relevant. One of my personal heroes as a judge is Judge Antonin Scalia. And he said he kept a stamp on his desk that said, stupid but constitutional. I could agree entirely with the plaintiffs that this sort of project is stupid and shouldn't be allowed. But that doesn't mean it's unconstitutional. This is a court of law. So looking at the counts that have been alleged, count 1, plaintiffs say adoption of a Creo violated Public Act 233, alleges that Sheboygan's Creo contains additional regulations that are impermissible under that statute about in which districts solar would be allowed, allowing solar as a use by right, and the voluntary standards in excess of the 5 standards in the statute. I agree with the defendants that the plaintiffs lack standing to argue that the Sheboygan Creo is illegal because it's too restrictive. Even if it were too restrictive, plaintiffs wouldn't be aggrieved by that fact. They want more restrictions rather than less. Plus, on its merits, the Sheboygan Creo is not more restrictive. The additional regulations are expressly voluntary. And even if the Creo impermissibly limited the districts in which a solar project could be situated, there's no aggrieved party here to that question, since the solar project that was applied for is in one of the permitted districts. So as to count 1, plaintiffs have indeed failed to state a valid claim on which relief could be granted, and there's no genuine issue of material fact. I grant the motion as to count 1 to both defendants. Count 2 alleges that the Michigan Public Service Commission order implementing the statute is unconstitutional under the non-delegation doctrine. This case doesn't involve the MPSC order at all. I'm not sure that I have the right folks in this case for me to have jurisdiction to invalidate that MPSC order. But even if I did, that wouldn't change a thing in this case. So again, there's no claim on which relief can be granted. There's no issue of material fact. Count 2, I'm granting the motion by both defendants. Count 3, violation of the Michigan Constitution vesting clauses. This alleges that legislative power is vested in the Senate and House, so no delegation of any legislative power to the executive is permissible at all. The relief requested is rather unclear. The allegations are fairly unclear. They're rambling and unfocused, uses a lot of constitutional language without really tying it to any particular claim or position. As best I can tell, it's an extension of count 2, the non-delegation argument, to say that the MPSC order is invalid. Same problems as with count 2. This case doesn't involve the MPSC order. I'm granting summary disposition to both defendants of count 3. Count 4 is equal protection. The Sheboygan Creo allows solar in 5 districts but forbids it in 15 others. Plaintiffs say that this is arbitrary and complete capricious and not rationally related to a legitimate governmental interest. This argument really does turn equal protection on its head. If anything, it'd be the defendants that would have the higher ground constitutionally here to say private property that wants to engage in a use of that private property and that complies with zoning. They have a constitution, the people that are leasing the property have a constitutional right to do what they want with their property. The leaseholder, defendant Northern Waters, has a constitutional right to use its leasehold interest in permissible ways. And the plaintiffs are saying that the government ought to stop private parties from doing what they want on their property and holding up the Constitution as their sword for it. That is very strange to me, very strange indeed. And it turns equal protection on its head. There's no injury to the plaintiffs here. The requested solar project special use permit was in one of the permitted districts. The project didn't move forward as a use by right, but under a special use approval process with a public hearing, comment, and findings by the Planning Commission. I'm granting summary disposition to both defendants of count 4. Count 5, substantive due process. It's unclear exactly what plaintiffs are arguing here, but I'm not sure whose due process rights would have been violated. The applicant would normally be the claimant in the due process violation. Plaintiffs have failed to articulate any protected constitutional interest that they're asserting, other than their belief that this CREO is arbitrary and was ill-advised. I think they have failed to state a claim, largely for the reasons in count 4 as well. I'm granting defendants' motion for summary disposition of count 5. Count 6, private nuisance, alleges that the plaintiffs are landowners adjacent or negatively affected by the solar project and that the project will interfere with the use and enjoyment of their properties. Summary disposition is generally premature when discovery is not concluded. There has to be some showing that the plaintiffs can be unable to present any evidence to support their claims. If this were at the end of the case, I would grant summary disposition. There hasn't been enough showing to survive summary disposition at the end of discovery. But at this early stage, plaintiffs have submitted affidavits about expected harms to them and expected harms to the use and enjoyment of their property from the solar project at issue, including some photographs or images or drawings of where some of their property would be situated in the midst of the solar panels. They've also submitted a report about the negative impact to real estate values from a certified master appraisal, although it's not connected specifically to the properties in this particular case. They also pled in their complaint allegations that the medical director of the St. Clair County Health Department, Dr. Nevin, has issued a report describing potential health hazards from industrial solar projects, and the plaintiffs have attached that memoranda in response to the motions for summary disposition. Again, that's not tied to this particular project. And I'm, as I sit here today, in large measure, fairly skeptical of whether the plaintiffs are going to be able to establish a private nuisance. But although the project has not been constructed, these are sufficient facts about potential harms to property owners different from the general public to avoid summary disposition before discovery. Given that some of these harms alleged involve permanent or substantial health hazards, waiting until those health hazards materialize is not necessary. I don't think this is wholly hypothetical. The project's been approved. There is a site plan for it. Again, it's too early to tell if the plaintiffs will ultimately succeed in their claims of nuisance. They have a tough road to hoe. But I think they have stated a valid claim on which relief can be granted under C8. And at this early stage, they have supported, maybe barely, but they have provided sufficient factual support to allow discovery. So I'm going to deny the defendant's motions for summary disposition of count 6, private nuisance. Count 7 is public nuisance. This is a fairly unclear argument. As best I can tell, the plaintiffs seem to allege that the project would have violated local zoning and be a public nuisance. So therefore, Public Act 233 itself, by coercing the county to adopt a CREO, essentially creates a public nuisance by allowing solar projects that would have been otherwise prohibited by local zoning. I think that's what plaintiffs are arguing. And I don't know, honestly, the nicest thing I can say about that count is that it's nonsensical. Public nuisance is where a use violates law or zoning. Here, this solar project does neither, but was expressly approved by the Planning Commission. This is definitely a failure to state a valid claim. I'm granting the motion for summary disposition of both defendants of count 7. Count 8, vagueness and overbreadth. Plaintiffs allege that the Public Act and the CREO are unconstitutionally vague or overbroad by requiring dark sky friendly lighting solutions. This is defined by statute as a light fixture designed to minimize the amount of light that escapes upward into the sky. Plaintiffs allege that people of common intelligence will have to guess at the statute's meaning. First of all, plaintiffs lack standing to challenge that lighting requirement since they're not subject to it. They're not injured by any vagueness. If, for example, an applicant for a project was denied, that their special use permit was denied because the Planning Commission said, your lighting is not dark sky friendly, then the applicant could bring forth a claim to say, well, that's too vague, or the way they applied it was improper. Plaintiffs are certainly not the injured parties by this regulation. And also, on its merits, there is absolutely nothing unconstitutionally vague or overbroad about that statutory definition. It's honestly better than lots of statutes I've read. The county brief at page 16, I think, states it very well. Quote, the requirement to implement dark sky friendly lighting is not vague. The actual party implementing these regulations, the solar company, has raised no complaints or confusion regarding compliance with this requirement. They have designed the lighting to minimize light that escapes upward toward the sky. End quote. And as I said earlier, if that definition is too vague, then I'm telling you, almost every statute on the books would be too vague, and our laws would be down to about a single volume of the Michigan compiled law. So that claim, again, is not well taken, not well pled. Granting summary disposition to defendants of count 8, vagueness or overbreadth. Count 9, conflict preemption. Plaintiff alleges that Public Act 233's prohibition on local ordinances adding more restrictions is illegal, and additional regulations would not directly conflict with the state regulation. Here, plaintiffs are essentially arguing that Sheboygan County could have adopted more restrictive regulations, but they didn't. So there's no conflict between Public Act 233 and the Sheboygan CREO. Plaintiffs have developed no argument with any citation to legal authority that a state statute can't prohibit local restrictions greater than the state law. State law can preempt the field entirely, as a statute does. MCL 123.1102 prohibits many local gun restrictions. And see Capital Area District Library versus Michigan Open Carry, 298 MISHAP 220 in 2012, where the state, for policy reasons, says we want to be pretty friendly to gun rights in Michigan, and so therefore, if local governments try to restrict gun rights too much, that's invalid. Well, if the state's entitled to do that for guns, it's entitled to do that for renewable energy, and they did. If a local regulation conflicts with state law, the state statute governs. And the state law says that a local zoning ordinance of certain solar energy facilities cannot impose additional regulations beyond state law. If a local zoning ordinance did so, then it would be in conflict, but here it didn't. So here there's, again, no valid claim that's been pled. There's no genuine issue of material fact. I'm granting summary disposition to defendants of count 9. That leaves the last count, an appeal. Plaintiffs claim an appeal from the approval of the special use permit. In the complaint itself, they haven't really articulated a lot of detail about that. It's not particularly unusual that the claim of appeal itself wouldn't have a lot of detail. The defendants want this court to grant summary disposition of the appeal, but I think it's apparent from my comments, I disagree that that's a proper procedure. Plaintiffs have included in this action an appeal by right of the zoning decision. That's governed by the rules of procedure, by the appellate rules of this court. By my review of the record on appeal has been transmitted, and the circuit court clerk mailed notice to the parties on 12/11 under MCL, under Michigan Court Rule, 7.111 sub A1A. That made the appellant's brief due last Thursday on January 8th, 2026. It, as of this date, has not been timely filed. Plaintiff's counsel articulated, kind of wanted to know what would happen here. It's understandable, but the rules of appellate procedure do apply. Under MCR 7.111 sub A1B, the circuit court may dismiss the appeal for lack of timely filing a brief on 14 days notice to the parties. So on today's date, I am right now signing a notice of intent to dismiss appeal that will be sent out to all the attorneys. That gives the plaintiffs 14 days from today's date, Mr. Delaney, in which to file your brief on appeal. Then the briefing schedule will continue to follow the court rules. The appellees may argue aggrieved party standing if they wish. Once the briefing is concluded under the appellate court rules schedule, the court will set it for oral argument if appropriate. Again, I may harbor some skepticism about whether the plaintiff's appellants will prevail on that appeal. By some of the comments of Mr. Delaney today, he may be relying on constitutional claims, which I think I've made apparent today. I don't put much water in, but I'm denying the defendant's motion for summary disposition of the appeal. It'll proceed as an appeal by right under the appellate rules. So therefore, on these motions, I'm granting both defendants' motions for summary disposition on all counts except count 6, private nuisance, and count 10, because it's premature in my judgment, and count 10, the appeal by right, because we have to follow the appellate rules in my judgment. Because defendants have prevailed on a majority of claims, Mr. Vogt, would you be able to submit an order either stipulated as to form or under the 7-day notice of presentment?
Yes, Your Honor.
All right, and also, since not all the claims have been dismissed, defendant Northern Waters now needs to file an answer to the remaining claims, since their motion for summary disposition was a responsive pleading. All right, and that leaves us, I'm sorry to everybody that's here for other matters. I'm significantly behind on my docket today, but we do have one more motion, plaintiff's motion to compel discovery. Maybe we can take that, on a more expedited basis. Mr. Delaney, go ahead with your argument on the motion.
In part, the motion to compel does address the earlier constitutional claims that we had in this case to answer those questions. But now looking at nuisance, for example, the county should be required to answer those questions because nuisance can involve these regulations from the county zoning ordinance before the Creole, even if the court didn't look at the ordinance of Sheboygan County. Under the nuisance claim, now these happen to be under the county, but I'm going to illustrate a point. My clients could claim impacts on wildlife, agriculture, water, visual impacts, hazardous waste, public safety, soil erosion, stormwater safety, tree plantings, berms. Again, these are from the ordinance. And if the county answers the questions, they can answer some of these questions. Impact on adjacent properties, infrastructure, traffic impact, environmental, market, fiscal, police, fire, health, road commission, environmental, substantial negative impact, glare, which was why I disagreed with the court earlier about the ruling on friendly lighting, as it affects adjoining landowners in this case and property values. Existing features on property, emergency vehicle access, county master plan. Those are all requirements that happen to be in the Sheboygan County zoning ordinance that are not in the Creole, but they relate to the client's claim for nuisance. And if the county is required to answer those questions that I submitted to them.
But your questions don't go to the nuisance. I mean, your questions are in large measure calling for legal conclusions.
Yeah, on use by right, for example, even though the court has addressed that under the constitutional, that would impact my client's value to the property. But see, I think that the arguments I made under the Constitution apply to the nuisance also. So even if you didn't apply the Constitution, which you did not in this case, they still apply under nuisance. My client's wildlife, his property values exist independent of that.
But why? I mean, you can, as you have today, presented some constitutional arguments, and your brother and sister counsel can do the same. But by what authority do you have that a party must answer questions you put to them about your constitutional claims.
Well, we don't have to use that label anymore. Now we can use nuisance.
Well, yeah, but if you're still asking for legal, I mean, I guess it sounded to me when I read you want me to compel answers to interrogatories, and when I read these interrogatories,
And they were drafted before the court's ruling and premised in part on the Constitution. I agree with that. So some of those questions, right, might not have bearing, but the county still has to answer the questions, even though they're not under the constitutional label anymore. Why are you only giving, under nuisance, this neighbor 5 protections when he should have 50? See, he has no protection. So when we get to the nuisance arguments, the county and EDP could say, we don't really care about the road.
well, I mean, the county, frankly, I don't know that I want to go back and revisit it, but I'm not sure why the county's a proper defendant as to the nuisance claim.
They
In
created.
fact, even if they approve it, it'd be the private party defendants that's the use of the property would be a nuisance. Maybe explain to me why even, well, I guess that's not an argument that was really made, so I guess I'll leave that for another
And I could
motion.
amend my pleadings, which would be permitted under the summary disposition, so long as they don't interfere with the court's basis of the ruling on the Constitution. But the court can take the label of constitutionality off, but it doesn't defeat the fact that under nuisance, we no longer have protection. We have an independent nuisance claim in this case, but now under the ordinance, because of the county's actions, we no longer have those protections. And I know the court moved on from the Hope case, but he had those protections. We don't. He could claim the road, he could claim the dust, he could claim the noise. I mean, they have decibel restrictions here on the operation itself. But I think it's a two-pronged attack here. Even if the court doesn't have that constitutional argument, my client can now claim that those protections are gone, whether they're constitutional or not. But they have them independent of the ordinance. But I still want the county to answer those questions. And maybe I need to revise the questions about why Johnson, for example, doesn't have protections that everybody else does.
All right, thank you, Mr.
Thank you.
All right, Ms. Cochran,
Thank you, Your Honor. Briefly,
it seems like these are asking for legal conclusions. You filed answers, except objected to the extent they asked for legal conclusions.
yes,
Is there
and
anything else I'm misunderstanding about that?
no, and the only thing I want to mention is the, principle of the relevancy of discovery. The party may obtain discovery on any non-privileged matter relevant to parties' claims and proportional to the needs of the case, etc. Evidence does not have to be admissible in order to be relevant, but it's not relevant in this case because now we're limited to private nuisance and the appeal. And because the motivations of the legislative body when they make their
Yeah,
decisions.
why
is
the
not
county
relevant.
adopted the CREO or not?
It does,
is
none of
not-
it's relevant under Sheffield Development versus City of Troy and Pythagorean versus Grand Rapids Township. None of it's relevant. And if you even look at the questions now, whether you want to call them constitutional or anything else your heart desires, they're calling, what is the difference between a voluntary regulation and workable ordinance? Does not matter, okay? What is the reason section 17.32.1 is a permitted use by right? None of this matters. None of the interrogatories that defendants have or plaintiffs have submitted to us are relevant in this matter, and we should not be required to answer them, and there should be no sanctions awarded. Thank you.
All right, thank you. Any rebuttal argument, Mr. Delaney?
No, thank you.
All right, the motion to compel discovery is denied. The county did file discovery responses. They objected to some of the interrogatories as calling for legal conclusions or not designed to elicit proper evidence. I agree with those objections. So the motion is denied. I'm not going to award costs. I mean, it was his motion to compel. I'm denying it. When I said prevailing party, Ms. Cochran, can you submit an order right back?
Thank you.
All right, so once we get an answer filed, we'll be in on a pre-trial scheduling conference. Parties can file additional motions if they want. If there's any amended completings or any additional motions, about discovery or at the end of discovery. Once we get the appeal briefs, we'll schedule that for oral argument, and we'll proceed as follows. Anything further from the plaintiffs, Mr. Flynn?
No, thank you.
Anything further, Mr. Vogt, from the defendants?
Just to clarify, 21 days from today to file answer an affirmative defense.
Yes, sir.
Okay, thank you.
Ms. Bachman, any?
Nothing further.
Okay, all right, thank you all very much. There was a lot of materials to go through. I thank you.
With that, the court made clear where it stood on this dispute. What unfolded over the course of the hearing was not a debate over whether the solar project was good or bad, or whether renewable energy belongs in the area. The court repeatedly narrowed the focus to a more limited question: whether this was the right forum and the right time for the challenge being brought. The homeowners raised concerns about how the project would affect their neighborhood, including land use, proximity to homes, and the scope of the development. They argued that the approvals process failed to adequately account for those impacts, and that the court should intervene before construction begins. Their position was that once construction starts, the harm becomes irreversible, and judicial review after the fact would offer no meaningful remedy. The town, however, had already taken a formal position. Through its local zoning and approval process, it reviewed the project, exercised its authority, and approved it. Town representatives made clear that this was not an informal or incomplete action, but a decision reached through established procedures. From the town's perspective, the legislative and zoning authority granted to it had already been exercised, and the matter had moved beyond the point where a court could step in to second-guess that decision. The developers echoed that position. Their argument was not focused on the merits of the project itself, but on process and jurisdiction. They maintained that all required approvals had been obtained, that the proper administrative paths had been followed, and that the challenge now before the court was untimely. In their view, the homeowners were attempting to use the courts to revisit a decision that had already been made through the channels set up for that purpose. Throughout the hearing, the judge returned to questions of authority, standing, and timing. The discussion centered on whether the court had the power to intervene at this stage, or whether doing so would amount to the court inserting itself into a legislative or administrative role. The judge also examined whether the homeowners were asking for judicial review of a final decision, or whether they were attempting to prevent a project that had already cleared the required legal hurdles. References to prior case law and legislative structure underscored this point. The court emphasized that not every disagreement with a local decision creates a justiciable controversy. Where zoning and land use decisions are made by the body empowered to make them, courts are generally limited in how and when they can intervene. Judicial review exists, but it operates within defined boundaries. By the end of the hearing, the court's position was clear. This case was not about evaluating the solar project itself, nor about reweighing the policy choices made by the town. It was about whether the legal process allowed the court to step in at this point. Based on the approvals already granted and the authority exercised by the town, the court concluded that the challenge did not fall within the scope of what it could review in this posture. In short, the court treated the issue as one of process rather than substance. The homeowners' concerns were acknowledged, but the court determined that those concerns had already been addressed, or should have been addressed, through the existing approval and legislative framework. With that, the court declined to intervene, leaving the approvals in place and the project to proceed under the authority already granted.